Hi, Tejasi, we are live.
Great. Thanks for that, Ashlesh. I'm going to go by the timer and wait 10 more seconds. But in the meanwhile, once again, thank you to everyone who joined today. Good evening. As you're aware, today we're going to be discussing and dissecting the Broadcasting Services Regulation Bill 2023. I'm delighted to introduce our speakers for today, Pallavi and Smith. Pallavi works in the public policy and advisory team at Ikigai Law. She advises leading technology companies, OTT platforms, social media platforms, digital media companies, and Indian and global industry associations on a variety of issues, including platform governance, content regulation, intermediary liability, data protection laws, as well as emerging technologies such as AI. She also has experience in strategic litigation for social media platforms on issues concerning licensing and acquisition of content. Smith Mehta is an assistant professor in the Center for Media and Journalism Studies at University of Groningen, Netherlands. He holds a Doctor of Philosophy in Creative Industries from the Queensland University of Technology, Australia. He is a critical media industry scholar, having published on issues related to creative labor, digital distribution, and cultural economy in leading journals. Smith has previously worked in Viacom 18 Media Private Limited as a content producer and is an author of the upcoming book, The New Screen Ecology in India, that articulates the digital transformation of the Indian audiovisual industries with the advent of streaming services. Lastly, I realize I'm yet to introduce myself. Hello, everyone. I'm Tejasi Panjiar, and I work as an associate policy counsel at IFF, and I'm your moderator for today. Now, for today, I'll start the discussion by setting some context for the bill and walking you through the various provisions that have gotten a lot of attention and not the good kind, to be fair. And we will then look at the bill and its flaws a little more closely as we move into the discussion with the speakers. And of course, the last 15 minutes of the call, we will reserve for audience interaction. Now, usually a lot of our calls are open to IFM members and donors, and we live stream to everybody else. But we knew that this call had to be open to everyone because this bill affects each and every one of us, and we'll get to know more about that soon. So we really want to hear from you what your thoughts, concerns, opinions, and questions are. So once again, thank you for joining us today. And if you enjoy today's conversation, please consider becoming a member and supporting our work so we can continue to fight to save these online spaces. Ashish, we can move on to the next slide. So on November 10th, the Ministry of Information and Broadcasting, or MIB, released the Broadcasting Services Regulation Bill 2023. And it was to cater, quote unquote, to the evolving needs of the broadcasting sector and in light of the technological advancements in the sector. Now, the bill aims to replace the Cable Television Networks Regulation Act of 1995, as well as other policy guidelines that were currently governing the sector. Now, why are we spending an hour discussing this bill today? Because it can have alarming consequences for our content and news consumption online. The uncensored Netflix and unprohibited news analysis by our favorite journalist may soon be under threat. So let's understand how. We can move on to the next slide, please. Now, the Broadcasting Bill expands the regulatory coverage of the Cable Act, which originally only governed traditional broadcasters, to include OTT content and digital news media under its ambit. Now, this is done to, quote unquote, capture emerging technologies. Now, OTT here is defined as on-demand or live curated catalog of programs made available to subscribers. So OTT platforms such as Netflix, Disney Hotstar, JioCinema, etc. are classified as broadcasting network operators, thus falling under the regulatory ambit of this bill. Now, coming to obligations imposed on such OTT broadcasters, they will only be allowed to provide service or operate if they provide an intimation to the union government of its operations. That basically means that they have to basically inform the union government of their operations in the country. Now, only such OTT broadcasters whose number of subscribers or viewers fall within the threshold prescribed by the union government will be required to provide an intimation. Now, what this threshold will be and how it will impact, say, small or medium scale broadcasters remains a mystery because that is yet to be prescribed. Moving on to the next slide. As you can see, the reasoning for the registration or intimation of a broadcaster has been stated as, quote, for the fulfillment of such social objectives as may be prescribed. Now, this is another instance of delegated legislation which may contribute to uncertainty and information asymmetry for the stakeholders. For instance, specifically in this case, in the absence of clarification or elaboration on these social objectives, it becomes difficult to understand on what basis or reasoning have the traditional broadcasting rules and codes been applied to OTT broadcasting services. So one could even make the point that the lack of insight into the government's rationale or reasoning for expanding this regulatory ambit inhibits the stakeholders' ability to meaningfully engage in the consultation process. Across the bill, there are several such unjustified instances of delegated legislation, which, in the absence of relevant safeguards to protect against arbitrary rulemaking, may lead to uncertainty in the industry. Now, Clause 8 states that the criteria for renewal of registration that are issued to such broadcasters. So the next clause states that the failure to comply with the terms and conditions related to renewal may lead to cancellation of the registration issued by the union government. Now, again, please remember all of this, the cancellation also does apply to OTT broadcasters, which may pose a threat to the industry's autonomy. The next clause deals with the suspension or revocation of the registration granted in case of violation of terms of conditions of such registrations. Now, given that the registering authority who may exercise this power will be notified by the union government itself, the executive has in a way retained power over the broadcasters through this clause. But it is worth noting that safeguards are built into clause 9. It does give a reasonable opportunity of being heard to the broadcaster, and it makes this mandatory before issuing an order of suspension or revocation. Now, clause 10 deals with the process of appealing against the decision of the registering authority. So safeguards such as reasonable opportunity to be heard are inbuilt under clause 10, subclause 2. What is unclear is, and it's something to think about, whether only the broadcaster may appeal the registering authority's decision, or if an aggrieved user of a broadcasting service may also appeal the decision. So for instance, if the registration of an OTT broadcaster such as Netflix gets suspended or revoked, it's unclear if an aggrieved Netflix subscriber can appeal the decision. Now, changing gears, moving on to the next slide. The bill states that any program and advertisement that's transmitted as broadcasting services must be in conformity of what is known as the program code and advertisement codes. For the purpose of this presentation, we will just refer to these two codes as the codes. Now, these codes already exist for cable TV and other traditional broadcasting services, and now these codes will also be prescribed for OTT broadcasting services. And if you're wondering what these codes will entail, don't ask us because they haven't been prescribed yet. Now, coming to one of the most scariest parts of the bill, adherence to these codes also extends to any person who broadcasts news and current affairs programs through a digital medium, for instance, your online paper, news portals, website, social media platform, or other similar medium. Now, this extends to individuals who broadcast news as part of a systematic business, professional, or commercial activity. So the independence of news publications like The Wire, Caravan, Scroll, Quint, even independent journalists like Ravish Kumar, Fede Souza, Rana Ayub may very well hang in the balance. And given how news and current affairs are defined, as you can see on the slide, even IFF may come under the regulatory ambit. Now, the definition, right? Quote, newly received or noteworthy programs, including analysis about recent events primarily of socio-political, economic, or cultural nature, end quote. Now, this is vague and broad enough to include a lot under its scope, and it doesn't actually leave a lot out of its scope. So this may affect online free speech as well as the freedom of journalistic expression, and may also threaten a user's right to access multiple diverse point of view because the individual broadcasting news will likely only produce content which is palatable to the union government, so as to avoid the penalty that comes with non-compliance. We will go more into the consequences on journalistic freedom and artistic creativity with the speakers after the presentation. So I'll pause on that bit here. Moving on, we'll move on to the regulatory structure. Yes, so the broadcasting bill suggests a three-pronged regulatory structure. Self-regulation by the broadcasters is first. Then there is the self-regulatory organizations or SROs. And the third layer is the Broadcast Advisory Council or the BAC. An interesting added layer here to the regulatory structure is the Content Evaluation Committee or the CEC. Now, basically, every broadcaster is required to constitute one or more CECs. The size, the quorum, and operational details of the CEC will be determined by the union government. And as the bill, broadcasters, interestingly, can only broadcast programs that have been certified by the CEC. There are also other compliances on the CEC. For instance, the names and details of the members of the CEC will have to be published publicly. Worth thinking about the kinds of risks and threats that such a provision may invite, given these platforms will only be allowed to broadcast the kind of programs that are certified by these members of the CEC. The bill also lists functions for all three tiers of regulation, and due to paucity of time, we won't go into that. But primarily, these are on compliances with the courts and on grievance redressal mechanisms. In addition to raising an appeal with the SRO, an SRO can also decide the punishment for non-compliance. Now, the punishment includes temporary suspension, expulsion from membership of the SRO, advisory, warning, censor, or even a monetary fine up to 5 lakhs. Now, coming to the infamous BAC, the bill allows the union government to constitute the BAC, which consists of an independent member, which will be the chairperson, and 5 ex officio officers representing various government ministries. So again, the BAC will primarily have 1 independent member and 5 government appointed ex officio officers. Now, the terms and conditions related to the appointment of the members, the manner of selection, tenure, manner of performance are all yet to be prescribed. And the current composition, as we've just discussed, does raise concerns around the council's autonomy. Now, the BAC may hear appeals filed by the complaints against the decision of the SROs, and it can also hear appeals that are referred to it by the union government. And after examining the complaints, the BAC ultimately has to make recommendations to the union government, which will then issue appropriate orders and directions. Now, here the ability of the union government to refer a complaint to a government-appointed body, as well as the power to issue final order on that complaint, is likely to pave the way for censorship as well as self-censorship. And another thing to note is, in light of increasing scrutiny of these streaming platforms, the government oversight over the BAC and CEC does raise censorship concerns. Now, quickly coming to the next slide. Clause 31 allows the union government to allows them the power to inspect, intercept, monitor, and seize equipment of broadcasting services. Now, yes, they will be required to provide a notice in writing informing them of the grounds for confiscation of such equipment, and will also provide them a reasonable opportunity of making a representation in writing. But the application of such powers on OTT broadcasting services raises concerns, again, about the executive's indirect control over the platforms. Next slide. Clause 35 does strengthen these concerns because it allows the government to delete or modify program or ads, even direct them to be off air for a specified number of hours. And this power is, again, the censorship power is cemented through clause 36(2), which states that in public interest, it may prohibit the operation of any broadcasting services in the areas notified. Now, comments on the bill have been invited till December 9th. Over time, our work around overregulation and curtailment of online curated content has been identified by the hashtag or phrase let us chill. And this is the exact plea we have to the MIB. So please join us in urging the MIB to let us chill. And in the coming days, we will start a campaign and publish details about how you can engage in the process and share your concerns with the MIB in only a matter of few steps. So do stay tuned. That brings me to the end of my presentation. Thank you for bearing with me. I think it was tough to cover everything in 10 minutes, but if you want to read more about it, please go through our first read of the bill, which is up on our website. And I will also share the link in the chat. And on a lighter note, do tell us if you think the title of the first read, which I will not tell you now, is cool or not, because there is an ongoing internal debate about this at IFF. So we'd love your thoughts. Ashlesh, we can stop presenting now. Thank you. Okay, now coming to the speakers, Pallavi, I'd like to come to you first. The very first thing that caught our attention was the proposal to bring both traditional broadcasters and OTT broadcasting services under a homogenized regulatory framework. Now, the MIB also retains the ability to bring under regulation any such service that it may consider to be broadcasting services in the future. Now, what, in your opinion, do you think will the impact be, especially on growth, innovation, and functioning of emerging technologies? Do you believe that there was a regulatory need to extend such a framework to the OTT space, and what could the potential intention be behind doing so?
Sure. Thanks, Tejasi, for that context. So yes, as we see, the bill is, MIB's attempt at bringing about a consolidated framework for all broadcasting services. You have cable, you have radio, television, satellite, and now internet broadcasting services also. And what they're including in internet broadcasting services is the term called OTT broadcasting services. And that's the first point of contention, right? Whether OTT content can even be called broadcasting. If you see the definition of broadcasting under the bill, it says one-to-many transmission of content, which is how broadcasting has traditionally been understood. It's public exhibition, which is cable and television and satellite and now direct to home that we see at homes. It's mass consumption of content, and it's what we call push content because the user does not have any control over what they want to watch. You have some control over the remote control, yes, but what a particular channel will show is not up to the user. The same channel broadcasts the same sort of program to everybody at the same time. Because of this mass consumption and public exhibition, the government retains some sort of control on what can be shown on TV, which is why you have the Cable Television Act, you have a program code, etc. But now through this bill, the bill seeks to introduce OTT as well within this ambit. OTT is something which is traditionally seen to be a private viewing experience. It's a personal consumption. And if you see the stats, most of India watches OTT on their personal devices, and it's also pull content because the users are able to choose what they want to watch at a particular time. So they have that complete sort of control and freedom. Which begs the question, right, whether the government needs to come and sort of regulate what people are watching on their, personal devices. That distinction between push and pull content, is there. So that's one. And as far as implications are concerned, right, on free speech, you have creative, artistic freedom, etc. I think the regulatory structure that you explained and the fact that now we have a CEC, there are going to be far-reaching implications because the Content Evaluation Committee is sort of a censor board for every OTT platform. If you see the wording of the provision, it says that even though the CEC is comprised of members of different social groups, the central government does have, oversight over how number of members, the quorum, as well as any other details which are necessary for the CEC's functioning. Now that language is broad enough for the government to sort of exercise arbitrary power on how the CEC will function. And considering the power that the CEC has, it's going to certify every program before it's sort of put on an OTT channel. It does, raise questions on what kind of content we're going to start seeing. It is going to have a chilling effect on free speech. OTT platforms will sort of want to self-censor and, show content which is palatable to the government narrative. So yeah, that's the sort of, there are initial thoughts on implications.
Pallavi, your point of pull versus pull, that comment was a great intervention. And we've also looked at, the very basic contradiction between the nature of cable TV and online curated content. And that did lead us to question the need for such a regulatory intervention. So thank you for your points. Now, Smith, coming to you, given your extensive research around the digital transformation of Indian media, the shift in creator cultures with the advent of OTT, do you think the bill will impact the dynamic and diverse creator community as well as the content they produce? And if so, how? And just to add, you've also researched on how broadcasters are moving towards creating original content independent of their television programming. Do you think this shift was possible and maybe even preferred because of the lack of compliances or regulatory burdens and curtailments? And will this sort of independence will now be affected due to the bill?
Okay, so I think we'll just go one by one because it's just a couple of brief questions. And first of all, thanks, Tejasi, for really introducing the bill with parsing it out with all the details. And Pallavi really made some very, very sharp points about how the censorship sort of is playing, through its arbitrary framing and stuff. Now, I worked at Viacom for 3 years before I started my PhD, and it was interesting. We had a legal team in place to look at some of the dialogues and see which of the dialogues can be contentious, how can we move our way around these dialogues. But I still vividly remember none of this. I'm talking around the time between 2013 and 2016 when I was at Motion Pictures and then at Woot. The launch phase of Woot. So around that time, I remember we were discussing about creating content, and there was already this chill, as again, what Pallavi mentions very briefly in our dialogue about this chill of what can we possibly show which does not offend. We are not talking about the citizens here, which does not offend the government. So it's really interesting for me how government frames these censorship policies, thinking that it's for the benefit of the citizens. So we introduce censorship as a welfare scheme, as something that's ease of living for the Nagriks. But who are the Nagriks here? Are the Nagriks just the government and its right-wing forces, or are we considering the aspirations and the viewing choices of the citizens who are in place? And, we can discuss around these bills with all these arbitrary framings from 1 to 10. We can do all of this, but there are just 2 points here very, very clearly. The Indian Cinematograph Act in 1918, the very history was introduced by the government, by the British Raj at that time, to curb the anti-colonial establishment sentiment. So they said, you cannot do something like this because if you start mobilizing, it's threat to our rule. Now, I have failed until now to see any sort of legislation that doesn't do this. So we talk about legislation that improves the welfare of the community. How about introducing a legislation post Me Too on the posh, at the production where movies are shot? This is for the welfare. How about introducing sanitization as a basic need for in production sets, and ensuring that broadcasters follow this suit? So what I'm basically trying to say is there are places where legislation is needed, which can improve the overall conditions of shooting or the overall content that is produced. But what you have essentially done is you are looking at every possible medium that is getting popular, and you're saying, okay, how do I control it? What are the various ways in which I control it? Of course, as again, going back to what you have mentioned, what Pallavi has mentioned already, this is a way, this is executionary, what you sort of use the word as delegated execution, of through this sort of lawmaking. So essentially intervening in a way that really sends a message to all. So and you briefly asked question about whether this has affected the creators. Of course it has affected the creators. Anurag was making, I think, Maximum City. Uh, Around my time, AIB was making Government, which was initially with the late Irfan Khan, which was, and all of these shows, I think they've been made and they've been stalled. So a lot of these things have already happened. So I'm unfortunately presenting a very pessimistic view, and my apologies for this, but I don't see any other way in which we can discuss this bill except for the resentment and the grievances that will come from some of the citizens who are reading this. So yeah, that's about it from my side. Thanks.
No apology needed, but we are with you on the pessimism. Your point about who this bill really serves, whether it's the interest of quote unquote digital nagriks or the government, was extremely pertinent and powerful. And thank you for talking about the intention, the need to control popular platforms, and the impact on creators. Pallavi, I want to come to you now and speak with you about the suggested three-tier regulatory structure. And you briefly mentioned it, but now this structure has a predominant self-regulatory approach, or that is how it is posed. Do you think it will play out as self-regulation, or would you say that it speaks the language of co-regulation in a much more skewed power dynamic situation, given the executive's control and oversight that's provided in the bill? And do you think the broadcasters will be able to retain their independence, or will we see a pattern of self-censorship in the presence of implicit or direct coercion?
Sure. So yeah, the regulatory structure, if you see on the face of it, it's very similar to the structure that we have currently under the IT rules. Of course, there's a stay on Rule 9 of the IT rules and by the Bombay High Court, and that's separate. But it's the regulatory structure under the bill is sort of similar. You have it does speak to self-regulation in the sense that you have a grievance officer at the OTT platform level. Then at the second level, you have a self-regulatory body, which currently also, there are self-regulatory bodies under the IT rules as well. And of course, at the third level, you have a broadcast advisory council. So on the face of it, yes, it's self-regulation. But if you actually read between the lines and you see the kind of control that the executive does have, the central government can decide the members and details of the SRB. The central government can decide quorum and members of the CEC, as well as the broad language that it can decide any details which are needed for the smooth functioning of the CEC. That language is broad enough for the government. And if you again see the amount of rulemaking power that the government has, it has about 60 plus avenues where it can actually frame rules. So that kind of power that the government has, yes, it probably speaks to a more co-regulatory sort of approach, something that, and this is also aligned with MIB's intention, right? And it ties back to the first question that you were asking on why did the MIB actually bring about this? And there are multiple factors at play. Of course, there is a stay on the IT rules. So this is one of the ways in which the MIB is sort of legitimizing this regulatory structure, which is stayed currently. Also, all the conversation on convergence that's happening, right, with the DOT, etc., also wanting to sort of regulate OTT services and MeTi coming in. But now, since there's been a change in the allocation of business rules, and MIB has sort of gotten control over OTT content and digital ads, this is also sort of MIB's way to sort of stake claim and take charge of the narrative on OTT platforms. So yeah, that's the intention. And there are obvious implications on free speech, considering the kind of executive control that the government has.
Thank you, Pallavi, for helping us with the nuance that's needed to read between the lines, because a lot of concern actually around the bill comes after doing so. And also, thank you for bringing into the conversation the various parallel developments that are happening, whether it's respect to the IT rules, part three of the IT rules, the stay on that part, whether it's the move towards convergence. All of that, I think, when we view all of these regulations, um, at the same time, there is definitely a broader pattern here that deepens these concerns for sure. Smith, I think the question to you now is, and now I'm coming to the application of a program code on broadcasters. And I want to understand whether it is the OTT space or the news media space, the application of these codes will have serious consequences on online free speech, on journalistic expression, artistic creativity, and like you mentioned, even viewing experience for users. Um, we may soon see, speech expressing satire, irony, sarcasm, dissent, anger, even maybe portrayals of facts and hard-hitting truth that may not be palatable to the union of politically influential communities being censored or prohibited. Um, Now, this may significantly alter the digital space, not just for creators, but for users. So, how do you think this bill will impact artists and creators, both small and large scale? Um, will it, and how, if so, will it alter the viewing experience for viewers? And again, if you've touched upon these points before, if there's any other additional comments that you would like to make, please feel free to do so.
Yeah, I think, whenever I look at a certain aspect of the bill, I look at the history of this sort of censorship bills. And I'm also looking at the history of the government in executing these bills, right? I've also written about this, and that's the reason I'm here. So when the Cable and Regulation Act was, introduced in 1995, there was this argument about the cultural invasion from the skies, right? So, you have the Star TV coming in and it would destroy the culture. Uh, what has possibly changed in this many years since that, and I'm thinking aloud now, is okay, there is one change in that there is a lot more activity from creators who are in India, who are questioning the government's social positioning, social, cultural, communal positioning on issues. And now that is being attributed to being anti-national. So the debate is now that the invasion is happening from within, not from the skies, right? And the consequence of this that I see is, one, of course, there will be more and more examples of censorship that will be introduced on Indians. But at the same time, there will be a lot of Indians who will go out and who will criticize India. So who will be putting up there will be a lot of activity amongst, the brain drain as we know it. There will be a lot of intellectual and critical thinkers who will go out of the country to sort of criticize India and then embrace being anti-national. So what we are essentially seeing is a divided identity of India itself. Like, you're not Indian if you criticize the government. You're not Indian if you go out. You're not Indian if you go out. First of all, your question itself, is about the identity. So changing the identity becomes a crucial way in which you can lure more nationalist sentiments. And this, of course, this is another complicated layer under this government where nationhood and identity are sort of then synonymous. And the idea of nation is a universal Hindu conforming belief. Anything that comes out of it is sort of exceptional, abnormal, even though history of India would suggest otherwise. So yeah, I think that's pretty much my thoughts on it.
Again, really, really powerful points. Um, so we can move to the Q&A part now, which I think we're most looking forward to, which is why we save most time for it. But in the meanwhile, till anybody has any questions, so A, you can raise your hand and you can unmute and ask your question, or B, you can put the questions in the chat. Meanwhile, Pallavi, if you also wish to give any closing remarks, anything we didn't end up covering, or your thoughts.
Sure, I think Smith mentioned one excellent point, which was that at his time there were legal teams sort of analyzing content, right? Which is, I would say, a lot of streaming platforms today have their own legal teams reviewing content, but that's not under government purview, which I mean the bill seeks to do, and that sort of alludes to my closing remarks that the attempt here is to consolidate. The hope is that it doesn't lead to censorship, right? That's the hope. We of course have to wait and see how the program code is going to look like. There's going to be a different program code for every broadcasting service. The one that we have for TV is of course very restrictive. It has vague words like decency and things like that, which may not work for a space like OTT. OTTs, it's the boom that's given us that edgy sort of content that could not be shown at other places. Creators have this sort of avenue to show that kind of content. So the hope is that it doesn't lead to censorship, and for that we have to wait and see how this bill sort of progresses and the rules come out. Yeah, those are going to be I want to end on sort of a hopeful note.
Yes, thank you for doing that. I think we needed that. Like you said, we can only wait and watch, and we can hope that this does not translate into becoming a tool for censoring content and dissenting voices, even more importantly. Anuj, I saw that, yes, you have your hand raised. You can unmute and ask your question, and then we have some questions in the chat that I will read after that.
Yeah, okay. Thank you. So the question I have is pertaining section 32 of the bill that enlists procedure about seizure of broadcasting equipment. So now I kind of want to have clarity on what are the affected parties, because some of the affected parties do involve independent journalists. And along with that, what kind of interim damage are we looking at? Because it says that the authorized officer may seize and given notice in 10 days, if I understand it correctly.
You want me to take that? Okay. Thanks, Anuj, for the question. When you say affected parties, what's not clear is whether this is actually applied to OTT broadcasting services at all. Because if you see, the registration requirement is restricted to only cable, television, satellite radio. OTT platforms are supposed to intimate. That's one. There's no registration there. There's an intimation. So in terms of OTT, what is the kind of equipment that they'll seize is something, we need clarity on. That's one. In terms of implication, this is something that's also this power of the government to sort of seize equipment if they feel that there's a violation after giving an opportunity of being heard. This is something that's also present under the Cable Television Network Act right now, for cable TV, etc. But now whether this will actually apply to OTT or not is something that we have to see. The good thing is that there is a sort of opportunity to be heard, and it's only then that that equipment will be seized, etc., in case there's a violation. But again, no clarity on for OTT what is the kind of equipment that will be seized, given that there's no registration also.
Pallavi, if I may quickly add something, or rather it's a question that I have right now, because I'm looking at the meaning or the definition of registration in the bill. And as per clause 2, subclause HH, it says that registration basically also includes intimation. So, and again, because the word registration is used throughout and not registration and or intimation. So I was also wondering, whether that means that it does not apply to OTT services. But given that it includes intimation, do you think that there is a possibility that then this particular clause will also be applicable to OTT broadcasters?
Sure. way I'm reading it is that what's the implication? How do you revoke an intimation? That's the only thing. Of course, it can, the definition says it'll include it. But when you say suspension of registration and revocation of registration, those are real consequences. But here, for OTT, there's an intimation. How will that be revoked is something that'll have to be seen. And this intimation is also something that's currently also there under the IT rules. If you see, OTT platforms today also have to furnish details of their operations, which is also now reflected. But because there is a revocation requirement also, we'll have to see how that actually plays out.
Yeah, okay. That's a fair point. Thank you for answering that, Pallavi. Now, Riju has a question. How does the criticism or commentary rules not run directly afoul of the fundamental right of free speech? And more importantly, will the courts protect a right in a legal challenge? Smith or Pallavi, would you like to?
Sure. It could very well be, if you see the challenges that the IT rules, faced. There are Bombay High Court, stayed operation of Rule 9 on the very reason that it violates Article 19, freedom of speech, etc., saying that this regulatory structure and the way that news agencies have to sort of comply with this is violative of free speech. So these provisions could very well violate free speech. That's one. Secondly, another very problematic aspect that I think we've not discussed till now is that how it impacts users broadcasting news. So if you have a user broadcasting news on a social media intermediary, I also have to comply with the program code, advertisement code. I also need to have a content evaluation committee. Now, how do you censor news? That's also something that may not pass the constitutional muster. So yeah, it's a matter of a legal challenge being filed. Yeah.
Can I just quickly make this point? This is, see, we have to understand here the adventurism of the government it's more to do with creating this effect, of we could do this. They started with IT rules. Before that, they went on to the Netflix, Amazon Prime Video offices, and they had this campaigns. The Hindu right-wing groups held meetings with them. There is already ample of evidence on that. The Hindu covered it, I believe. The Hindu newspaper covered it. So the point here is this is already leading to invisible censorship. It's not about how this plays out. It's about how it has already played out. It has played out. We have seen the effect of this on creators, on people do not want to be the next Aparna Purohit, who have to then go and stand in front of the court and then being told you are liable for this, you could possibly face jail. So this is happening as we speak. Whether this act gets passed or not is, they've already set a precedent for it. That's my point.
Absolutely, we agree with the fact that such pieces of regulation and legislations are meant to create a culture of fear, and we've seen that play out. I think most people here would have read the Washington Post story. If someone could post a link to that as well in the chat. So I absolutely agree on that point. And I think the next question is, if the government already had the digital rules in place, why are they passing another bill? If this is a reference to the IT rules, again, like I think Pallavi also alluded to that, and both Smith did as well, right? Like, obviously the challenge on the constitutionality of the very part, that is part 3 of the IT rules, which is administered by the MIB, is a reason to introduce, one could speculate is the reason to introduce this particular bill, and to sort of sidestep the entire sort of legal challenge, and to sort of cement the MIB's power to actually exercise these kinds of powers over the online curated content and news that is broadcast, but to also, as been mentioned, to just create that fear, that culture of fear that ultimately leads to self-censorship, because there is a lot at stake. Yes, Smith.
Just one point on this. See, the intention is very clear here. You need to centralize this regulation. If you cover everything under one ambit, it creates a uniform regulation process. It's easier for the government. So it's more than anyone, it's ease of regulation, which is what I argue in my article in Indian Express. It's ease of regulation more than anything else.
Absolutely, Smith. Thank you for that. Seema, ma'am, you can unmute and ask your question.
Thank you. Yes. I just a thought on the IT rules. If they have IT rules, why are they doing this? Precisely because of that. You see, these are just executive things that these are like file notings almost, the IT rules, because they've not taken it to Parliament to give this draconian structure, parliamentary sanction, and get it called law. So basically everything which is informal, chilling, pilling, all of that is now being formalized and codified into law. So it's really like Hammurabi's sort of equivalent of the draconian kind of, regime in India. But anyway, that's just a thought on why they're probably doing this. My question is, I think the most fundamental point as a news person that should lead us to kind of tear up this bill is the fact that while the entertainment sector, if you like, or, as you said, what was very wonderfully defined by a speaker as the push content agreed to, which is the non-news sector, agreed to a CBFC or a certification process. By this, you're beautifully bringing the entire news architecture of new media under that, without a discussion, without a thought. That for me is the most fundamental switch. So far, news is not pre-censored. Whatever Times Now has to say, NDTV has to say, Ravish has to say, YouTube has to say, by this, you're breaking the fundamental principle of what has been accepted. So for me, how to kind of really organize ourselves against that principle that they are violating. The rest is a matter of detail because it's just taking us down darker and darker alleys. But they've fundamentally gone down and put us at par with Mughal-e-Azam or Sholay being released. That now news will need to kind of be pre-censored. So that for me is the most scary thing of this bill, I think.
Absolutely agree with that. I think very sneakily done. So a matter of 4 or 5 lines. But when you think about the kind of implications it will have on online free speech, on again the journalistic expression and their freedoms is extremely scary, which is why I said one of the most, arguably the most scary part of the bill. Pallavi or Smith, if you want to, I know we've spoken about that before, but if you want to add to something or respond.
Is Pallavi around?
I think she
No, I can't
just,
see her.
maybe there is
Yeah.
some network issue.
No, but so I think, first of all, fantastic point from Seema, when we are covering the entertainment sector for a while, you sort of switch off to the nuances here and there. And I think she made a wonderful point. And my question is, again, it's even perhaps it's like a question that I can just shout out loud, and Tejasi, if you might want to add. So what happens to this live reporting, and what happens to this news debates that go? How are they sort of then censored? So I'm honestly, this is again the question that I have just from hearing how the wonderful point that Seema made, and unfortunately I'm not really equipped to make any comment on that. So if there is a way in which I think Pallavi is back, and if she can have a point on this, and if Tejasi you want to add something, and if Seema can again join in, that would be great.
Sorry, I think I lost network. I heard a bit of what Seema was saying, completely agree. The question was asked, why the bill if the rules are already in place? We have to understand that the MIB's part to actually execute part 3 is also under question, because the IT rules are framed under the IT Act, right? And a lot of powers that the MIB has under the IT rules is something the IT Act does not. The IT rules itself are under question or under challenge, and this is sort of a way to step back, give MIB's powers legitimacy. That's one, and completely agree on the news aspect. Like I said, a person broadcasting news will have to comply with everything that OTT broadcaster also does, which includes something like a content evaluation committee. And it brings me back to the point on how do you self-censor something like news? To me, that's completely something that will not pass a constitutional challenge, violates free speech, and has very far-reaching consequences for something like journalistic freedom, which is something that we need to push back against the most. Because I'll make the point on push versus pull content again. The fact that you have executive control over content on TV, on cinema, is because it's mass consumption. And there's a reason for that. The government wants to sort of control what's viewed, across all ages, across all audiences, where you don't have control over what you're watching. But something like news, something like OTT content is not that kind of not that medium. And do we really need that kind of executive control over content like this? We have to see, but of course, I would say that that will not pass free speech challenge.
Just to quickly add to that, so on the point of Smith, your question, right? Again, I would go back to the definition. That is, I think, to subclause B, and how vaguely that's been defined, right? It includes audio, visual, and audiovisual programs or live programs, right? And it also includes analysis. So, like I mentioned, like we're unsure if something like an organization like IFF would also come under this, and I think it does exclude sort of online newspapers, and if there's something that's being aired on television, just its replication is also excluded. But given that newly received or noteworthy programs on social, political, economic, cultural nature, given that this is the ambit of the definition that can possibly extend to mean anything, that's extremely concerning. And on the point of free speech, I definitely think that regulatory power to censor or prohibit content that's published by news broadcasters extend beyond permissible restrictions on free speech, free expression that's allowed under Article 19(2). So I think definitely it's extremely concerning, and thank you, Seema, for raising that very pertinent point. And I do agree we need to tear this bill apart, definitely on several points, but on this one. So I think Meghnath has a question. Want to ask a similar question to Smith. I stream news on YouTube. How will that be affected? And I see you've responded to that.
Yeah, I think I just responded to that because these are all very pertinent questions, and I think we have to seek more clarifications as well from the government on what they mean when they,
On that, actually, I spoke about that one line, to fulfill social objectives. This bill, yes, has an explanatory note, but does not come with a white paper or, on their reasoning or justification or rationale for introducing, such a bill, and then expanding the scope to not just the OTT space, like Seema mentioned, but also sneakily introduce 2 paragraphs, which then expands it to the news, digital media sector.
Yep.
He continues. Yes, Smith.
No, it's just one point that I was thinking of. One of the clauses says regarding the seizure of equipments is there will be an authorized officer who will work under the influence of the government here. So you are authorizing an officer who's your representative to decide on when something is objectionable and how this will turn out. So this is where everything basically is clear. If you go into the weeds or you don't go into the weeds, prima facie you want to censor.
Absolutely. Meghna, to your second question, will individual creators who cover current affairs be required to have a self-regulation system? How is that even possible? I'll just read out 20 subclause 2 that says the provisions of this act as applicable to OTT broadcasting network operators shall also apply to the persons referred to in subsection 1, and the central government may prescribe rules and issue guidelines under the provision of this act. So everything that's applied to the OTT broadcasting network operators, including the 3-tiered regulation structure, will also apply to news broadcasters. And
just yes. One comment on how is that possible, or how is that going to work out? I think if you look again at the history of the government, whatever becomes popular, any sort of criticism, look at the To India, from stand-up comedian, who won the Emmy right now, forgetting his name. Veerdas, had a commentary on. Thank you, Riju. He made a commentary on two Indias. He was, he was violated, desecrated. He was commented upon, and things were said. Whatever criticism gets popularity becomes the subject of censorship immediately. So, the moment you become very popular and get known for, people follow you, that basically gives them the chance, or this rule basically gives them a chance to sort of exercise their executionary power in just from the way the government has been functioning.
Thank you, Smith. Riju has another question. Has there been an instance of public comments changing the bill? Net neutrality with Facebook comes to mind, but are there any recent precedents? Yes.
For example, so the one that comes to my mind is the telecom bill, because, of course, there was also an uproar on OTT services being included within the telecom bill. So that's one instance. Yeah.
We'll get to see the reported revised version of the telecom bill, and we'll know more then, but yes, definitely. I think recently TRAI also released a paper on regulation of OTT communication services and selective banning of OTT services. I think same, a lot of uproar against that bill. Understandably so, it deserved that scrutiny because it had implications on so many levels for the privacy, end-to-end encryption, innovation, user experience, so on and so forth. So that's another instance that comes to mind. And that's, we had the Save the Internet movement for the TRAI OTT consultation paper, and we intend to do a similar campaign for this bill as well, because I think it requires that level of mass, just campaign and just expression of anger almost with this bill and the kind of consequences that it can have. We have some more time, and yes. Yeah.
Just one point.
Sorry.
It's a very small point. Sorry, Pallavi, you were saying something. Sorry.
I was saying interesting that they just brought up selective banning, because there is a provision in the bill that people are reading as selective banning, which is, the government has the power to sort of prohibit the operation of any broadcasting service in any area. And that's another example of a sneaky little thing happening, right? If you see the IT rules, if it says that if there's a problem with content, the government can sort of modify or delete that particular content, but cannot ask the entire entity to stop its operations. But we see a reverse happening under the broadcasting bill, whereas, the government has the power to sort of seize the operations. So we can actually, now OTT platforms will be running with the fear of them having to shut shop. It's not about a particular piece of content anymore. And India is an important market for these, platforms. So that's also going to weigh on their minds when content is being developed.
Yeah. Yep. Yeah, I think I almost forgot the point that I was trying to make, but well, if it comes, then it comes. Yeah.
Absolutely, sir. And so this question by Shruti that says that is that different? I think the clause that Pallavi is alluding to, is that different from Section 19 under the Cable TV Act? Let me just, in really bad formatting, paste the Section 19, which basically refers to the power to prohibit transmission of certain programs in public interest, very similar to the language that's used in the broadcasting bill. Again, if it's not in conformity with the prescribed program code or advertisement code. This language actually, especially that bit on the grounds that are stated, is also very similar to clause 35 of the bill, which I think also includes, just opening that, or rather no, clause 36 subclause 1, right, which mentions similar grounds, almost the same, now that I read it, the same language. So yes, it's clause 36 1 and subclause 2, quite similar to Section 19 of the Cable TV Act. Shruti, great interventions. We are 1 minute over time, but again, I'm really enjoying this conversation. So if anyone has any further questions or comments to make, please feel free to do so if that's okay with the speakers. If an individual shares news using something like torrent, would he be considered a broadcaster?
I think my understanding, and correct me if I'm wrong here, you're already outside the purview of the legal infrastructure when you use pirated services. So, and piracy is already defined within the other clauses here, within the other clauses of the Indian Regulation Act as a illegal service which is detrimental to the the economic. Although we've seen many benefits of it, especially likes of Anurag Kashyap in watching films that were censored. So anyway, yeah, I'm not going to wade into the debate anymore on this. Oh, torrenting isn't illegal, it's just a protocol. Okay, so then again, see, there you go. That's a faux pas on my part, I suppose, from a legal standpoint.
I would correct me if I got the question right. It says whether if it's a torrent website and whether that'll be included within the ambit of the bill, right? So I would say, again, because the definition of broadcasting is so wide, and the government has the power to sort of include any other service which they think is connected to broadcasting service, I would say yes. Yeah, that's the initial reading, but again, it's not clear. The bill is not clear whether they'll actually be included, and it's something that we'll have to see.
Thank you, Pallavi. Thank you, Smith. Riju has a great point. The entire digital space seems to be under threat, ranging from platforms, the people working for the platforms, and the people using the platform. History shows that it will always be a failed gambit, trying to control what people see, think, and feel, especially in a 1984-esque dystopia. When will the government learn? I don't know. You tell me, when will the government learn? I guess that's the question on all our minds. Hopefully soon, but I think that's being too optimistic. But on that note, I will say that the government is inviting comments till December 9th. So please, I hope that after this call and after listening to the speakers' excellent inputs, you have the motivation to engage with the ministry through this public consultation process. We will be attempting to make that process easier for all of you. I would also say that if you like today's call and the work that we've done around the online curated space and otherwise as well, and if you want to contribute to the vision and mission of IFF, please consider donating to us. We are a small team of 7 full-time staffers, and trust me, each contribution matters. Our membership starts at really reasonable slabs, so do check it out at internetfreedom.in/donate. Thank you to everyone who joined. Yes, Riju, we will be having a templatized response. We will soon be publishing a detailed comment as well that we'll be sending, and a shorter version that everybody can share with the ministry as well. Thank you to the speakers. Thank you for taking your time for your excellent interventions, and hope we can have these conversations, especially on this, because it's very, like Seema said, important to discuss this better. So thank you, everyone. Have a great day, and please, again, to consider engaging in the public consultation process. Have a great day.
Thank you, everyone. Thank you, Tejasi.
Thank you, Pallavi. Thank you, Smith.
Thank you.